Hello everyone, welcome to another edition of Tips to Top the Unofficial Bar. Today I have with me a very senior lawyer, Mr. Chandaka Jayasundere. He is in the profession for over 20 years now, and he is specialized in the area of maritime law and transport law, and he is going to share with us tips to top the unofficial bar. Welcome to the show, sir.
Thank you.
Would you first tell us the beginning of your professional career?
I got entrance to law college as well as the law faculty in 1987, but unfortunately the universities were closed for 3 years. So
At that time?
And I had finished law college by the time university started.
Okay.
I got dragged twice, and so then I did my first in-laws while I was apprenticing, but then with starting work I thought it's better to focus on practicing and maybe get the educational qualifications later. So I took courts in 1991 and didn't complete my LLB. Technically I'm a dropout, but I did go back to the University of Colombo later on and got a master's again and specializing in international trade law. Then subsequent to taking oaths, I started apprenticing with Mr. Kanagishwar, and from there onwards I continued in his chamber till after about 8 to 10 years, started on my own, and on my own I have been now practicing for about 10 years.
When you begin your career, did you had idea that you will be specialized on this area of law? Or what was your idea at that time?
Well, I was always fascinated with transport. My initial ambition was either to be a ship's captain or a pilot, but because of my eyesight, both options were not available. And anyway, I'm fascinated with transport. Even now I can go and like sit in an airport, powers, train stations, ports. I just like the movement. So it was basically I've always been fascinated with shipping, and I had an idea that ultimately it will have to be something to do with transport.
Right. I'm sure with this 20 years of experience, you must have had number of unforgettable memories in your professional career. Maybe in the courtroom, maybe when you deal with corporate clients. Would you like to share with us some of those experiences which you think helpful for the law students and young lawyers?
Most unforgettable right through my career was working with Mr. Kanagishwar, because his approach to the law and the way he handles a case is always fascinating to watch. Even now, after so many years of practicing, it's still fascinating to see how he approaches a question. So most memorable is working with Mr. Kanagishwar. Of course, I had enough and more incidents, getting scolded by judges, scolding judges. Particular incidents, of course, one of the most interesting times was when Mr. Jayasundere was the Admiralty judge. I in fact learned Admiralty judge because of that, and he had this tendency of turning up in court at the most unusual hours. So we used to go and sit at 9 o'clock. I was Mr. Kanagishwar Junior. He might come at 10, he might come at 9:15, he might come at 12:30, 2:30, 4:30. So basically you have to just sit and wait for him. And after some time, I think, so sitting there was nothing else to do than study your case and also listen to Mr. Kanagishwar about Attonery-at-law. And so like for hours we used to stay, and the furthest time I have worked there is till about 8 o'clock in the night. During that time there was a storm And you know that the big Nugagaha in the High Court quadrangle, there was lightning and branch fell, there was no lights, and we were actually taking our coats off, waiting to go. So it was 6:30 in the night. Mr. Desmond Fernando and I was supposed to. And then suddenly there was this candle on the bench. See, Mr. Jayasundere was ready to go on. So he got 2 candles for us, for the 2 counsel, and then we went on for about another hour in absolute darkness. That was, those days it was not as, I don't know, it may be the amount of work that we have now, but those days it was much slower and there were much more characters. We used to have absolute characters as judges and as lawyers also. Now we are very, very professional, very clinical, but still interesting. Then I have got, I also, during the time I started with Mr. Kanageshwaran, I also worked with Mr. Kaling in the Tisa when he came out from the department. And I used to go outstation because what I was told was that the best experience is the experience you get on your feet. And you can't make mistakes in serious cases, but you have to get that experience on your feet. So I have appeared all over the place, and magistrates court, high court, and especially magistrates court because I was specializing in civil law. Most of the criminal law I practiced, I learnt on my feet. So I worked with him. I have travelled from Hambantota to Anuradhapura, Kandy, and basically the experience I got was the experience that you get on your feet, because you can learn all the texts in the world, you can memorize all the judgments in the world, but when you do a trial, and even if you have your best submissions ready to make in court, if the other side comes with something unexpected, it's what you do on your feet that really matters, and for that you need experience. So what I tell my juniors also is it's pointless sitting around. You have to watch trials, but better experience is do a trial. Do the small cases. It doesn't matter, you won't get paid, you won't get good cases, you always get the bad cases, the dead cases. But you do, and when you win a dead case, that gives you much greater pleasure, even the smallest case. Maybe for those days we used to do 100,000, 200,000 claims, absolutely dead for defenders, especially bank cases. But then you try to find ways out of, and you think outside the box. So that experience you get not by sitting in chambers or walking behind a senior. You have to do it without sacrificing your work with your senior. Maybe in your free time you must do litigation. If you are doing litigation, and if you want to practice, you must have experience on your feet, and especially sections and how judges react, how judges act. Most of the judges are very good with juniors, they help, even now. Some don't, but most do. They give a better hearing if you are a junior. So it's always better to get your experience on your feet. But to do that, you must know your stuff. Don't know your stuff, you can't fudge. The law is something you can't fudge. So you must know your basic law. You must know your substantive law if you are specializing in something. But that background work has to be there. Without that, you might be the most articulate, but you must know what you are talking about.
Sir, now correct me if I'm wrong. I feel only few number of lawyers are going to, especially young lawyers, going to the area of maritime law, despite the fact that we have Colombo port, one of the best ports in the world, and I think that handles annually over 5,000 ships. Why is that? Maybe is it problem that we are not majority not interesting to learn maritime law, or whether we don't have much cases in the maritime?
I think the main cause is that we don't have cases because we are not known as a maritime jurisdiction. We were known as a maritime jurisdiction. There was a lot of cases when we started, but somewhere down the line it just dropped off. Sri Lanka, the port of Colombo, if I am not mistaken, is somewhere around 27th or 30th in the world, not Asia, in the world. We are the fourth largest or third largest exporter of tea. We are in first three or four. Garments. So we being an island nation, we have to be interconnected. And there is a thriving maritime industry. But the input from the legal side, be it litigation, be it legislation, is very poor. One of the main reasons is that, say, compared to Singapore, Singapore is the main maritime litigation hub or jurisdiction in Asia. We have some systematic problems in the administration of maritime matters, in the judicial, the court structure, which of course now it's almost non-existent because now admiralty work, we can, those days, now with the commercial high court doing the admiralty work is much faster. So work has started coming back again. So I think because of that, and there were some certain other administrative issues, because of that litigation, admiralty litigation has dropped a lot. One other reason is that litigation in shipping law is always relative to the freight rates. Because if the freight rates are high, then the ship owners will want the ships to be earning money. So if there are claims, they settle and take the ship out. If the freight rates are low and there's a dip, then they would rather have the ships inside port without expending too much. So you say till 2009, 2000, I think it started with 2008. There was a boom in shipping because of China, and it's still booming. There are huge new ship builds, and they are all coming most probably somewhere next year or the year after. So because of that, and Chinese trade to the States will go through the Pacific, and so because the freight rates were so high that it was easier, or it was better for owners not to go into litigation but to settle. But now with the recession, there are cases coming up where shipping companies do falter, and because of that, litigation has dropped. Then the other main reason for litigation to drop is containerization, because when it is containerization in admiralty, because admiralty relates to the ship, because of containerization, damage to cargo is much less now. Those days it was, they used to get, I started, it was cement, sugar, fertilizer, Bombay onions and potatoes, and they used to carry it in, like the whole ship was full of Bombay onions, and they were really rickety old ships, and invariably during monsoon there would be damage. They used to bring cement, cement gets hard, and they used to bring sugar from Brazil, and on the way it gets damaged. So because it was bulk cargo, so and then because of the ships are also old, there was a lot of litigation on those. But with the containerization in the late 80s, early 90s, now all that cargo comes in containers, so damage is minimal, and if there is damage, most of the cases will now be money recovery and not admiralty. But that, having said that, that is admiralty. the litigation with regard to international trade, including shipping law, has not decreased. It's the same. It is not a huge amount, but it has not decreased. Those are mainly contractual claims, which are money recovery cases, not admiralty cases. Admiralty is unique because you need the ship within the territory. But other international trade cases, LC issues regarding LCs, those are still there.
Let's come to talk about you in this 20 years long career. What is your secrets of success? Would you like to share those things maybe unique to you? Particularly when you handle a case, when you have a corporate client, or when you face a judge, or when you make your submission, what is your unique?
If you are a trial lawyer, you must be a master of facts. You must know the facts from the start to the finish. You must, although it is not used much, you must master the evidence ordinance. You must master the civil procedure code. You can win trials on the evidence ordinance. There are enough sections in the evidence ordinance which can win you trials. So you must know your evidence ordinance, you must know your civil procedure. Also you must know your facts, and all that entails a lot of hard work. And one other thing again I learned from Mr. Kanagishwaran is that you must be aware of the world. You must know what is happening in Colombo. You must know what is happening, say, now I'm doing shipping. You must know what is happening in the international shipping.
On the side of
not the law, but the business of shipping. Not that I have to do business, but you must read. Say, if you are doing intellectual property, there's such a lot of developments going on with these Apple, Samsung cases in the States. And so those things you must learn. And now, those days we only had the books. So they sound a bit old. We had a time when we didn't work with computers. So now you just take your tablet and the notebook and you have everything. You just have to access. And Apple, Samsung cases are so widely reported. Since you have the tablets now, most of the time when in court, waiting for my cases, I basically read.
I see.
Which we couldn't do those days.
Right.
Bringing a phone into the courthouse was frowned upon. Now people use laptops and even the tablets. And I also think that technologically you must be savvy. Because now the clients, the industries, they are not like us. We are still reading our law books. They are in a different world technologically. With regard to, say, shipping, bills of lading, everything is done by electronic communications. You have electronic bills of lading. Some are now, most are now being done by SMSs. So the contract might be on 2 SMS text messages or emails. Emails we have no problem because the law has changed, accepting those. But even then proving an email is pretty difficult. Now there's one case with regard to this, with text messages where you take the photograph and that becomes, I think Justice Chittaciri held that in the High Court, that the photograph of the text message is valid evidence. But the text message itself is still not valid evidence. But then huge trades, huge contracts, at least not the formal one, but the initial negotiations are on text messages maybe. So technologically we have to develop, you have to develop, and you must keep pace, especially if you are doing, like, specializing in intellectual property, even company law, maritime law, shipping law. You must keep up with the changes in the world. You might not be able to use it, or you might be able to use it when some guy comes and starts pontificating.
You ought to have tools ready.
You have to have them ready, because and you must also know other things than what you know, right? You must read. You know, it's tough because you're always reading. So what I do is, and you are always reading legal texts. So what I do normally is I read absolute trash outside, outside of my legal work. In the night I would read not trash but light stuff. But during the holidays I would read history. History is very important, and a knowledge of the wider world and knowledge of human beings is very, very important, because when you are cross-examining, when somebody says something, you must know where he is coming from, and you must know why he is saying it, what is his cultural background, his maybe economic background. So those are very important if you are trial, not if you are a corporate lawyer sitting in an office, but if you are a trial lawyer, you need those, because when you are cross-examining, you must have, because you can I wouldn't say trap them, but you can make them unsettled by knowledge that he would never think that a lawyer would have. One example I would say was, I remember Mr. Kanagishwaran was cross-examining this guy, and his education was an issue, and when Mr. Kanagishwaran asked what was your basic degree in, and he said existentialism. I didn't know what existentialism was. But then Mr. Kanagishwaran asked if it was in existentialism. Do you know Sartre, who is considered the father of existence? I know now. And that guy didn't know. And from that day, that time onwards, the cross-examination he was eating out of Mr. Kanagishwaran. So that kind of knowledge is very necessary if you are a trial lawyer.
So you as a lawyer, you want to know not only the law, but outside the world.
Definitely. Especially about human beings and human knowledge.
So finally, what is your advice for young lawyers and law students, those who want to specialize in maritime law and transport law?
Yeah.
Do they have to do something extra than an average law student?
I think the problem we have is, one other problem we have is that nobody teaches maritime law in Sri Lanka. There is a diploma course run by an institute, but other than that, nobody teaches. Specialization also, now I did my master's later on in life. I did it on multimodal transport, but because I wanted it, and the university was good enough to say that you can do that. But if you are doing maritime law, the litigation is, the amount of litigation is very, very small. So, but that doesn't stop you from specializing in it. But there are enough and more situations you can work in most of the big companies, but that will be corporate work. But I also think if you are specializing, you must have some something new that likes that field. Then it becomes that much easier. If you like company law, how companies work, how directors work, then it's better. If you like transport like I do, then you have something emotional bond with the subject. But it's basically now you have to, not like those days, now you have to specialize. You can't jump from chamber to chamber, go from senior to senior, trying to figure out what you are now. These days the kids are much more focused, they know what they want. So I always say that you have to be loyal to a chamber, apprentice, work with your senior, because you learn from them. If you keep on flitting from one chamber to the other or doing work on your own, you will never learn. You have to learn the law and how you conduct yourself from seniors. And I had the good fortune of working with Ms. Kanagishwaran. So, if you are specialized, and there are enough senior lawyers now specializing in specific niche areas, and also other way of doing it is you decide on say corporate law, and you do corporate work, but you must have your core competency in one particular subject. Now I do, other than shipping, I do company work, company law, banking, and a little bit of intellectual property, but my core competence is shipping and maritime law. So you have to do the other ones because the bread and butter comes from doing money recovery cases and all that. But you must have your core competency, and that is the one you must focus on. If you are doing further studies, you have to get your studies on those subjects. But generally you can do all the others, but you must have your core competency.
Thank you very much, sir, today joining
you.
with us and sharing your valuable tips and experience for the young lawyers and others. Thank you very much.
Thank you.